Thank the gentleman from New York. The chair will now recognize himself for 5 minutes of questions. It strikes me that the law can require action or forbid action. The law can forbid the possession of child pornography. The law can, in some instances, require you to file an income tax return. Mr. Lazarus, is the chief executive constitutionally capable of ignoring both categories of law?
Well, as I said several times, Congressman Gowdy, the President cannot refuse to apply or enforce a law for policy reasons.
Well, let's analyze that for a second. Congress decided in its collective wisdom that if you possess X amount of a controlled substance, you are going to get X amount of time in prison. You may like mandatory minimums, you may not like them. This administration summarily dispensed with that law. So my question to you, again, is can the chief executive fail to enforce categories of law that are both permissive and mandatory?
Well, it is well established that the executive branch has prosecutorial discretion to decline enforcement.
And what are the limits of that prosecutorial discretion?
You know, very frankly, I'm not an expert on that.
Well, let me ask you this. Can the president, let's assume that a statute required you to show 2 pieces of identification to purchase a firearm. Can the chief executive knock that down to 1?
I guess I'd have to know a little bit more, but I would...
It's a very simple fact pattern. You have to show 2 forms of ID to possess or purchase a firearm, Can the chief executive, under his pardon authority or his prosecutorial discretion authority, knock that down to just 1 form of identification?
Well, I'm not aware of limits on the president's pardon authority.
So you would say he could?
Under the pardon authority, the president can pardon just about anyone, not that he should. No.
Even before the act is committed?
That's the reason for...
Can he do it before the act is committed? That's my question.
I'm sorry?
Can he do it before the act is committed?
Again, that's above my pay grade. I don't really know that.
If the president can fail to enforce immigration laws, can the president likewise fail to enforce election laws?
Whether the president can pardon someone before a prosecution is initiated or before an act?
Well, I think I know the answer to that question. My question was before the act was committed. He certainly can before the prosecution. My question is this: if you can dispense with immigration laws or marijuana laws or mandatory minimums, can you also dispense with election laws?
Again, I think we've gone over this ground many times.
Well, just humor me. Let's do it one more time. Can the president suspend election laws?
No.
Why not? If he can suspend mandatory minimum and immigration laws, why not election laws?
Because we live in a government of laws, and the president is bound to obey them and apply them.
Well, he's not applying the ACA, and he's not applying immigration laws, and he's not applying marijuana laws, and he's not applying mandatory minimums. What's the difference with election laws?
We have a disagreement as to whether, in fact, he is applying those laws.
Did he?
My view is that he is applying those laws.
Did Eric Holder instruct his prosecutors to no longer follow the mandatory minimums with respect to charging decisions?
Now, this is an area where I really don't know nearly as much as you do, Congressman.
I'd find that shocking that anybody would not know more than I do on any topic. Who would you like? You want me to ask Professor Turley?
That my impression is that he's not exactly doing what you've just said.
Well, tell me how I'm wrong, because Eric Holder sent out a memo that we are no longer going to put in the indictment the drug amounts. Do you agree with me that Congress can pass mandatory minimums?
Constitutionally, yes.
Do you agree that Congress can pass statutory maximums?
Pardon me?
Can Congress also pass statutory maximums? In other words, you can't get more than 30 years for a crime.
Of course.
Can a president exceed a statutory maximum?
Can he extinguish, did you say?
No, can he exceed it?
Can he exceed it? Well, how would he do that? I mean, keep someone in prison beyond his prison term.
Well, if you can put them in prison for less time than Congress says is the law, can you also do it for more time than Congress says is the law?
It's really, it's not. This is kind of fruitless because it's an area that I really don't know.
Professor Turley, what are the limits of prosecutorial discretion? And if the president can suspend immigration laws, marijuana laws, why not election laws?
Well, I think that in some of these areas I can't imagine can be justified through prosecutorial discretion. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. Prosecutorial discretion is a case-by-case decision that is made by the Department of Justice. When the Department of Justice starts to say, we're going to extend that to whole sections of laws, then they are engaging in a legislative act, not an act of prosecutorial discretion. Wherever the line is drawn, it's got to be drawn somewhere from here. It can't include categorical rejections of the application of the law to millions of people.
Well, my time is up, but I would just tell you that I always thought prosecutorial discretion was an individual prosecutor determining whether she or he has enough facts to substantially result in a conviction on a case-by-case basis. If a president is ignoring entire categories of the law, whether it be immigration, marijuana, mandatory minimum, the ACA, what is the remedy for the legislative branch?
Well, first of all, the first part of that question is, as you may know, I do criminal defense work. I would never go to a prosecutor and say, I want your prosecutorial discretion to say that the entire class of which my client belongs cannot be subject to this law, because prosecutors would look at me and say, are you insane? I am not Congress. So I wouldn't even raise the question. Now, in terms of where we go from here, I'm not too sure, because the great concern I have for this body is that it's not only being circumvented, but it is also being denied the ability to enforce its inherent powers. Many of these questions are not close in my view. The president is outside the line. But it has to go in front of a court, and that court has to grant review. And that's where we have the most serious constitutional crisis I view in my lifetime. And that is, this body is becoming less and less relevant.
With that, we would recognize the gentlelady from Texas, Ms. Jackson Lee.
Let me thank
Madam Attorney General, the central issue to me is this perception, frankly rooted in some realities of a dual-track or two-tiered justice system. And I know that you have dedicated your career to the pursuit of justice. I know you work for a blindfolded woman who's holding nothing but a set of scales. And I think it's important that she's blindfolded because she shouldn't see race, the gender, the socioeconomic status, the fame or lack of fame of the person in front of her. And I'm sure you've experienced it like some of the rest of us. It's not just the suspect or the target or the defendant. The witnesses have to have confidence in the justice system. The jurors have to have confidence in the justice system. The public has to have confidence in the justice system. So this dual track, different set of rules for certain people than for others. It frankly should not matter whether you are running for president or running late to a kid's ball game. The same rules ought to apply to everyone. So let me ask you this. Why do you think it's important to use official email to conduct official business?
I believe it's important to do that. I think that certainly every department has chosen to craft the way in which they carry out their business, and it provides for a way of doing business in a secure system.
So you use official email to conduct official business?
Yes, sir, I do.
Okay. And do you ever email, send or receive classified information on personal email?
I do not.
I doubt you even use your USDOJ.gov account to send classified information, do you?
We have separate systems.
Right.
So there would be a separate
classified system
for that.
Right. So not only do you not use personal email to do it, you don't even use your USDOJ.gov. You have a separate, dedicated system to handle classified information. Why?
We have a separate system to handle the security needs.
But my question is why? Why is it important enough to you to not use personal email to conduct public business and to use a separate, more safely guarded system when you do handle classified information.
That is the practice that I've certainly always followed. It
But it's
allows for
not
the
just
protection.
it's not just a personal preference, is
No,
it?
it allows for the protection of the information, both on a regular system, because again, that's still sensitive, law enforcement types of matters, and then a classified system for separately classified information.
What element do you think was lacking in the statutes that you evaluated as it relates to Secretary Clinton?
So let me, again, as I've indicated before, and I want to make it clear that, as I indicated before, while the reason why I would not be going into the analysis that was provided and the discussion that we had between myself and the team is because we protect our teams and that they have to be free to provide information and analysis in a confidential way without the fear or impact of there being a political influence on that.
I understand
and that is why
that.
I have not gone into that type of discussion. What I can tell you is that the team did evaluate the relevant statutes that were considered in this investigation. They looked at all of the facts and evidence, and as in every case, they applied them to that statute to determine whether the elements had been met.
But my specific question to you, Madam Attorney General, is what element of which offense did you find lacking from an evidentiary standpoint?
Well, I would say that in order to answer that, I would have to go into the entire level of analysis.
Don't you think
Yes.
public perception in a single track justice system is important enough that you could at least touch on what you thought was lacking?
Congressman, in this case, we have taken the unusual step of discussing it in ways that the department typically does not, in order to provide more clarity into this situation. And while I understand that it is frustrating to a number of people, civilians as well as members of this body, we have taken extraordinary steps to discuss this matter in ways that typically we do not,
Let me ask you
particularly when
this.
charges are not brought. And as I indicated before, just so it's clear, my reasons for not going into the substance of the information that I receive and review before I made my decision to accept the recommendation are that the teams that I work with, whether it's this case or any other, be free to provide confidential analysis, discussion, without the input of any
With all due
kind of
respect,
political
Madam Attorney General,
influence.
you can do all of what you just described and still tell the people what element. I mean, the elements of a criminal offense are public, so there's no secret there. And for you to go through the elements and say, as Director Comey did, he said there was no specific intent. I'm out of time, but I suspect you have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the department or personally?
No, just as a prosecutor. There's involuntary manslaughter. There's reckless homicide. There's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
Well, Congressman, as I've said, I think you've mentioned a number of state cases there. But as I've said, the reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone to their decisions, nor will I apply one in accepting their decisions. That's why we have taken the unusual providing greater information, as frustrating as that has been for a number of people to have additional information. That's why I took the unusual step of clarifying my role in this investigation.
Well, I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to. But right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did or whether President Clinton could do exactly what Secretary Clinton did. And I think that lack of clarity is bad for the Republic.
Well, I'm going to help you with it, okay? Spoliation of evidence is when a party fails to preserve evidence. There's a negative inference that the jury can draw from their failure to preserve the evidence. You with me? If you destroy documents, the jury can infer that those documents weren't going to be good for you. If you fail to keep documents, the jury can infer that those documents were not going to be good for you. You've heard the phrase spoliation of evidence, haven't you?
I can't recall ever hearing it.
It's true in administrative hearings, civil hearings, criminal hearings.
I practiced law once 45 years ago, gave it up for Lent 1 year, never went back.
All right. Well, let me tell you what you would have found if you had stuck with it. When a party has a duty to preserve evidence or records and they fail to do so, there is a negative inference that is drawn from their failure to preserve the evidence. It's common sense, right? If you destroyed something, the jury has a right to infer that whatever you destroyed would not have been good for you, or else every litigant would destroy whatever evidence was detrimental to them. Agreed?
I'm not sure. I think if you destroy the evidence and people could prove it, it wouldn't be a good thing for your defense.
Well, no, it's worse than that. The jury can draw, and they're instructed, they can draw a negative inference.
All right?
And that's true if a taxpayer is being sued by the IRS administratively, civilly, or prosecuted criminally, and they fail to keep documents, the jury can draw a negative inference from the fact that they didn't keep receipts or emails or documents. So if it's true and applies to a taxpayer, it ought to apply to the IRS as well. Agreed?
Is this a trial? Is this a jury? Is that what you're...
I said administrative, civil, or criminal. If you want to go down that road, I'm happy to go down it with you, Commissioner. In fact, I'm glad you mentioned it. You have already said multiple times today that there was no evidence that you found of any criminal wrongdoing. I want you to tell me what criminal statutes you've evaluated.
I have not looked at any.
Well, then how can you possibly tell our fellow citizens that there's no criminal wrongdoing if you don't even know what statutes to look at?
Because I've seen no evidence that anyone consciously...
Well, how would you know what elements of the crime existed? You don't even know what statutes are at play. I'm going to ask you again. What statutes have you evaluated?
I think you can rely on common sense that nothing I have seen...
Common sense. Instead of the criminal code, you want to rely on common sense. No, you can shake your head all you want to, Commissioner. You have said today that there's no evidence of criminal wrongdoing. And I'm asking you what criminal statutes you have reviewed to reach that conclusion.
I've reviewed no criminal statute.
All right, so you don't have any idea whether there's any criminal conduct or not because you don't know the elements of the offense.
I've seen no evidence of wrongdoing.
Oh, well, that's very different from no evidence of criminal misconduct, Commissioner.
Well, it seems to me if you haven't done wrongdoing, it'd be pretty hard to argue that you've had some criminal violation if you did.
Well, what did Lois Lerner mean when she said perhaps the FEC will save the day?
I have no idea
what did she say? What did she mean when she said we need a project, but we need to be careful that it doesn't appear to be per se political? You don't think that's a potential violation of 18242?
I have no idea if it...
Because you haven't looked at 18242, and you don't have any idea, Commissioner. You don't have any idea whether there's any criminal wrongdoing or not.
With regard to the production of the evidence, the production of Lois Lerner emails, I have seen no evidence of wrongdoing. What else went on?
Well, if there were, that would be a separate criminal offense.
What else went on with Lois Lerner, I said in the past.
So what you're saying is you don't have any idea whether she engaged in criminal wrongdoing. You're just saying that you did not engage in any with respect to the emails.
I haven't seen any wrongdoing with regard to the production of Lois Lerner emails.
But you are not saying there was no criminal wrongdoing with respect to the targeting of conservative groups. I want to be very clear. You're not saying that.
I've made no judgments.
So you disagree with the president when he says there's not a smidgen of corruption?
There are people who have been making judgments both sides about whether there were...
And you know what? I'm not one of those. I'm just simply saying we will never know because you didn't keep the evidence. The evidence was spoliated. And whether it's negligent, whether it's intentional, whether it's reckless, we still don't have the evidence, Commissioner.
Well, you have the evidence that there is no emails from the White House. You have all of the Treasury emails. So the basic premise that this was an argument in a conspiracy driven by the White House does not...
No, sir, you're wrong about that. You're wrong about that. That you're repeating a talking point from our colleagues on the other side that we're obsessed with the White House. It was Jay Carney who perpetuated the myth that it was 2 rogue agents in Ohio. It wasn't any of us. Was that accurate? Was that first initial line of defense that this is just 2 rogue agents in Ohio? Was that accurate, Commissioner?
Not that I know of.
All right, so that wasn't accurate, and that came from the White House. Who said there's not a smidgen of corruption? Who said that, Commissioner?
My understanding is that was the president.
It was the president. So that's Jay Carney and the president both inserting themselves into the IRS scandal. And you want to blame us for bringing the White House into it?
I haven't blamed you at all.
You just did, Commissioner. You just did.
Well, it's a good argument. All I said was the White House has revealed there were no Lois Lerner emails. Treasury has given you all of their emails. So to the extent that the argument was that Lois Lerner was conspiring and emailing back and forth, thus far, I haven't seen any.
But you can be engaged in a conspiracy that doesn't include the White House.
Gentlemen.
Good. I think time's up. Right. Thank you, sir.
Good morning, Director Comey. Secretary Clinton said she never sent or received any classified information over her private email. Was that true?
Our investigation found that there was classified information sent.
So it was not true.
Right. That's what I said.
Okay. Well, I'm looking for a little shorter answer so you and I are not here quite as long. Secretary Clinton said there was nothing marked classified on her emails either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Secretary Clinton said I did not email any classified material to anyone on my email. There is no classified material. Was that true?
There was classified material emailed.
Secretary Clinton said she used just one device. Was that true?
She used multiple devices during the 4 years of her term as Secretary of State.
Secretary Clinton said all work-related emails were returned to the State Department. Was that true?
No, we found work-related emails, thousands, that were not returned.
Secretary Clinton said neither she nor anyone else deleted work-related emails from her personal account. Was that true?
That's a harder one to answer. We found traces of work-related emails on devices or in Slack space, whether they were deleted or whether when a server was changed out, something happened to them. There's no doubt that there were work-related emails that were removed electronically from the email system.
Secretary Clinton said her lawyers read every one of the emails and were overly inclusive. Did her lawyers read the email content individually?
No.
Well, in the interest of time, and because I have a plane to catch tomorrow afternoon, I'm not going to go through any more of the false statements, but I am going to ask you to put on your old hat. False exculpatory statements, they are used for what?
Well, either for a substantive prosecution or for evidence of intent in a criminal prosecution.
Exactly. Intent and consciousness of guilt, right? Is that right?
Right.
Consciousness of guilt and intent. In your old job, you would prove intent, as you just referenced, by showing the jury evidence of a complex scheme that was designed for the very purpose of concealing the public record. And you would be arguing, in addition to concealment, the destruction that you and I just talked about, or certainly the failure to preserve. You would argue all of that under the heading of intent. You would also be arguing the pervasiveness of the scheme, when it started, when it ended, and the number of emails, whether they were originally classified or up-classified. You would argue all of that under the heading of intent. You would also probably, under common scheme or plan, argue the burn bags of daily calendar entries or the missing daily calendar entries as a common scheme or plan to conceal. 2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be president since Jefferson. He didn't say that in 08, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. So you have a rogue email system set up before she took the oath of office, thousands of what we now know to be classified emails, some of which were classified at the time. One of her more frequent email comrades was in fact hacked, and you don't know whether or not she was. And this scheme took place over a long period of time and resulted in the destruction of public records. And yet you say there is insufficient evidence of intent. You say she was extremely careless, but not intentionally so. You and I both know intent is really difficult to prove. Very rarely do defendants announce, on this date, I intend to break this criminal code section. Just to put everyone on notice, I am going to break the law on this date. It never happens that way. You have to do it with circumstantial evidence. Or if you're Congress and you realize how difficult it is to prove specific intent, you will formulate a statute that allows for gross negligence. My time is out, but this is really important. You mentioned there's no precedent for criminal prosecution. My fear is there still isn't. There's nothing to keep a future Secretary of State or President from this exact same email scheme or their staff. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to Commander-in-Chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be. With that, I would yield back. We will not waver in our commitment to see that justice is done for this terrible act in Benghazi. And make no mistake, justice will be done. That was the President of the United States over a year ago. We're investigating exactly what happened, but my biggest priority now is bringing those folks to justice. That was the President of the United States over a year ago. No one has been arrested. No one has been prosecuted. No one has been brought to justice. We don't even have access to the witnesses. You and the media were good enough for my 16 years as a prosecutor not to tell me how to do my job. And so far in Congress, y'all have been good enough not to tell me how to do my job. I'm not telling you how to do your job. But I'm going to ask you some questions, and if you can't answer these questions, then I'll leave you to draw whatever conclusion you want to draw about whether or not the media has provided sufficient oversight. Can you tell me why Chris Stevens was in Benghazi the night that he was killed? Do you know? Does it bother you whether or not you know why Chris Stevens was in Benghazi? Do you know why we were the last flag flying in Benghazi after the British had left and the Red Cross had been bombed? Do you know why requests for additional security were denied? Do you know why an ambassador asking for more security days and weeks before he was murdered and those requests went unheeded? Do you know the answer to why those requests went unheeded? Do you know why no assets were deployed during the siege? And I've heard the explanation, which defies logic, frankly, that we couldn't have gotten there in time, but you know they didn't know when it was going to end. So how can you possibly cite that as an excuse? Do you know whether the president called any of our allies and said, can you help? We have men under attack. Can you answer that? Do any of you know why Susan Rice was picked? The Secretary of State did not go. She says she doesn't like Sunday talk shows. That's the only media venue she does not like, if that's true. Why was Susan Rice on the 5 Sunday talk shows? Do you know the origin of this mythology that it was spawned as a spontaneous reaction to a video? Do you know where that started? Do you know how we got from no evidence of that to that being the official position of the administration? In conclusion, Congress is supposed to provide oversight. The voters are supposed to provide oversight. And you were supposed to provide oversight. That's why you have special liberties, and that's why you have special protections. I am not surprised that the President of the United States called this a phony scandal. I'm not surprised that Secretary Clinton asked, what difference does it make? I'm not even surprised that Jay Carney said Benghazi happened a long time ago. I'm just surprised at how many people bought it. Thank the gentleman from New York. The chair will now recognize himself for 5 minutes of questions. It strikes me that the law can require action or forbid action. The law can forbid the possession of child pornography. The law can, in some instances, require you to file an income tax return. Mr. Lazarus, is the chief executive constitutionally capable of ignoring both categories of law?
Well, as I said several times, Congressman Gowdy, the President cannot refuse to apply or enforce a law for policy reasons.
Well, let's analyze that for a second. Congress decided in its collective wisdom that if you possess X amount of a controlled substance, you are going to get X amount of time in prison. You may like mandatory minimums, you may not like them. This administration summarily dispensed with that law. So my question to you, again, is can the chief executive fail to enforce categories of law that are both permissive minimums? What's the difference with election laws?
We have a disagreement as to whether, in fact, he is applying those laws.
Did
My
he?
view is that he is applying those laws.
Did Eric Holder instruct his prosecutors to no longer follow the mandatory minimums with respect to charging decisions?
Now, this is an area where I really don't know nearly as much as you do, Congressman.
I'd find that shocking that anybody would not know more than I do on any topic. Who would you like me? You want me to ask Professor Turley?
That my impression is that he's not exactly doing what you've just said.
Well, tell me how I'm wrong, because Eric Holder sent out a memo that we are no longer going to put in the indictment the drug amounts. Do you agree with me that Congress can pass mandatory minimums?
Constitutionally, yes.
Do you agree that Congress can pass statutory maximums?
Pardon me?
Can Congress also pass statutory maximums? In other words, you can't get more than 30 years for a crime.
Of course.
Can a president exceed a statutory maximum?
Can he extinguish?
Do it before the act is committed.
That's above my pay grade. I don't really know that.
If the president can fail to enforce immigration laws, can the president likewise fail to enforce election laws?
Whether the president can pardon someone before a prosecution is initiated or before an act?
Well, I think I know the answer to that question. My question was before the act was committed. He certainly can before the prosecution. My question is this: if you can dispense with immigration laws or marijuana laws or mandatory minimums, can you also dispense with election laws?
Again, I think we've gone over this ground many times.
Well, just humor me. Let's do it one more time. Can the president suspend election laws?
No.
Why not? If he can suspend mandatory minimum and immigration laws, why not election laws?
Because we live in a government of laws, and the president is bound to obey them and apply them.
Well, he's not applying the ACA, and he's not applying immigration laws, and he's not applying marijuana laws, and he's not applying mandatory.
Did you say?
No, can he exceed it?
Can he exceed it? Well, how would he do that? I mean, keep someone in prison beyond his prison term.
Well, if you can put him in prison for less time than Congress says is the law, can you also do it for more time than Congress says is the law?
It's really, it's not. This is kind of fruitless because it's an area that I really don't know.
Professor Turley, what are the limits of prosecutorial discretion? And if the president can suspend immigration laws, marijuana laws, why not election laws?
Well, I think that in some of these areas I can't imagine can be justified through prosecutorial discretion. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. Prosecutorial discretion is a case-by-case decision that is made by the Department of Justice. When the Department of Justice starts to say, we're going to extend that to whole sections of laws, then they are engaging in a legislative act, not an act of prosecution.
And mandatory.
Well, it is well established that the executive branch has prosecutorial discretion to decline enforcement.
And what are the limits of that prosecutorial discretion?
Very frankly, I'm not an expert on that.
Well, let me ask you this. Can the president, let's assume that a statute required you to show 2 pieces of identification to purchase a firearm. Can the chief executive knock that down to 1?
I guess I'd have to know a little bit more, but I would.
It's a very
inclined to
simple
think
fact
not.
pattern.
I
You
would
have
be
to show
inclined to
two
think
forms of ID to possess or purchase a firearm. Can the chief executive, under his pardon authority or his prosecutorial discretion authority, knock that down to just one form of identification?
Well, I'm not aware of limits on the president's pardon authority.
So you would say he could?
Under the pardon authority, the president can pardon just about anyone. Not that he should. No.
Even before the act is committed?
That's the reason for
Can he do it before the act is committed? That's my question.
I'm sorry?
Can he